All right, let's get started. Welcome to the first of these lectures. Today I'm going to cover just kind of general topic overview stuff. The schedule had said 3 hours. I think that's a little long to grant to y'all, so I'm not going to do that to you yet. You will probably at some point get the 3-hour-long BK ramble, but not this morning. Instead, what we're going to do is we're going to keep it to about 2 hours, but split it into kind of 2 chunks. And the first chunk is going to be covering sort of the basics of this topic from sort of a substantive perspective, giving you all some important kind of background knowledge on the topic itself. The second piece is going to be taking some of this then and applying it to the particular resolutional wording that we have in order to sketch out in a little bit more detail, what are some of the potential affirmatives that you all might encounter, what are some different competing visions for what this topic might look like, particularly because there's a separate T lecture later in the camp, but that's going to be first and foremost focused on kind of like topicality as applied, rather than some of these kind of bigger picture questions about like what are different ways that one could understand the contours of what it means to, for example, strengthen IP protections or IP law to be domestic versus not, and so on. I will, before I dive into this, I would be remiss to not preface this by saying I am absolutely not an expert in this area. I think a little bit of knowledge is a dangerous thing. I do not, so like on the one hand, I don't mean that to imply that I don't have any idea what I'm talking about here or that I haven't spent a good amount of time researching this stuff or whatever, both kind of over the years and more recently. But I absolutely am not an IP lawyer, and by extension, you should take everything I say today with a significant grain of salt. If in the course of your research over the camp or later in the year, you discover something that you think conflicts with this, that's very possible. If a topic expert says something different to you later on, or whatever, that's also a thing that you should understand as superseding this. And in general, I think there's a useful lesson embedded in that, right? There are issues on which I would feel comfortable describing myself as a subject matter expert. Like I'm in the security studies program here at Georgetown. If this were the nukes topic or about military operations or logistics or whatever, I could freely, extemporaneously talk to you about it all day and have a very high degree of confidence that the things that I'm saying are true and accurate. Here, I tried to be very careful to not include anything in this lecture that I am not reasonably sure is an accurate characterization of this stuff. But there's still an important difference there. So want to be open about that. Okay, the structure of this is going to be this. We're not going to go kind of like totally in order left right, but this is the kind of general outline for this first part. We're going to start by talking about rationales undergirding IP protection. Then we're going to talk about kind of each of the discrete topic areas. We will do a short. There is not as much Blackboard space as I wish there were, and earlier when I was experimenting with it, if I go too low here, then you all are not able to see it. So we'll do like a short 5-minute thing, a short 5-minute break here in between patents and the rest of it, because patents has kind of the most for us to get through. But there are some terms for copyright and trademark and stuff that I want to have up here on the board for reference while we're talking through this. Then once we've gotten through each of those areas, we will briefly discuss potential alternatives to IP law that are capable of arguably serving some of the same sorts of objectives that we're going to be talking about for each of these areas. That survey will be relatively brief but important because it helps kind of tee up some of the later conversations you'll be having during the camp, future lectures, et cetera, about things like counterplans, right? As well as like critique alternatives. At that point, we'll break probably for 10 minutes. And then maybe 15, we'll kind of like see how we're doing time-wise. Knowing myself and that I tend to be long-winded, I suspect we'll only have time for 10, we'll see. And then we'll come back and reconvene and do the let's diagram the resolution and talk about how some of these things play out. Make sense? Last thing I'll say before I dive in is if at any point you are kind of lost or you feel like you have like a question directly related to something I've said here or whatever, please feel free to shout that out there. Raise your hand, but also feel free to just say something, because I think the odds that I don't see you, definitely possible, would prefer to field your questions. If something comes to you after we've moved on from it, and it isn't directly relevant to what we're still talking about, or it's like not really directly related to any of this, but just like, you know, something we say sparks it, then please jot that down so you don't forget it. We'll have a dedicated Q&A session at the end. Again, how long this takes will determine exactly how long that is, but I'm anticipating probably 15-ish minutes. And then you'll also be able to kind of further debrief all of this in lab. Is that good? Okay, rationales for IP protection. So the reason that I wanted to start here is really all of these other sort of like legal and policy questions, not to mention, you know, questions of like ideological and philosophical underpinnings that y'all will delve into in like the K lectures and stuff, are like first and foremost require an understanding of what set of objectives these laws are seeking to serve and how we're going about trying to maximize those objectives. Because, for instance, like whether it's the statutory design piece of this or the way that some of those standards are and have been kind of administered over time by the courts, which we'll kind of like talk through in some amount of detail. All of that is guided by, and not necessarily guided by sort of an overarching theory of what it is we're trying to do. Broadly, so there are a variety of potential answers to that question. Broadly, I think that there are two that I want to call to your attention. The first being the utilitarian theory of IP law. This is and has been since the very beginning what guides and undergirds the IP regime in the United States, which has not necessarily been the case in some other countries, and there are people who believe that this should change here as well. And so that, you know, those last two things are part of why we'll talk about these other alternatives by comparison. But yeah, utilitarian theory, the core, you know, the TLDR here being that the goal of the patent system is to maximize societal benefit by best balancing the incentives for inventors to invent, you know, or in the case of copyright or trademark law, to engage in commercial activity that is like beneficial societally with the kind of societal benefit of this, right? So it's like fundamentally there are two stakeholders you're trying to serve here. One is the individual, right? When somebody, the idea is that in order for somebody to be sufficiently incentivized to pour in all of the time and money and effort required to create an invention, or invest in the very large, you know, capital costs often required to bring that invention to market, especially initially, right? Like you're building some sweet new widget, you have to invest in the workforce required to design and figure out how it should work, and you have to invest in factories to construct it and whatever. And fundamentally, anyone who comes along later has, if you pretend that patents, for example, didn't exist, anyone who comes along later has very large advantages, right? They're able to come to this once you've already figured out what the best version of that widget looks like. They're able to kind of, you know, draw from that set of ideas of yours. They're able to come potentially enter the marketplace once you've already figured out much more cost-effective ways of manufacturing the thing, right? And so there's a real danger here that a potential inventor, knowing this, will never engage in inventive activity to begin with, or if they do, will never engage in the process of converting that inventive activity into an actual product, or, you know, kind of selling that product, right? Because they know that if they do, they'll just be kind of screwing themselves over, because I'm going to bring this thing to market, someone else is then going to just like copy that for less and make a bunch of money for it. So the idea that the reason that the U.S. patent system cares about this, at least in theory, is not because we think it is unfair to somebody to have produced the thing and not gotten the returns for it. We'll talk about that way of understanding this in a minute when we get to the locking part of this. But rather, that if people expect negative or kind of neutral returns on innovation, like we just sketched out, then they won't engage in that innovative activity. That's bad for society because we like innovation, we like inventions, and we like for the economy to grow and all that sort of stuff. Does that make sense? Do you have the constitutional provision part of section 1? Okay, yeah, great. So section 1, article 8, clause 8, I believe, of the Constitution, or sorry, article 1, section 8, clause 8, says that lays out the kind of initial constitutional basis for the federal government having authority to grant patents in the first place. We'll talk about this in more detail when we get to the patents part, but part of the reason that grant of authority is important is because fundamentally patents are a monopoly, right? In the sense that you're saying, you get to do this thing, no one else can mess with this thing, which is a pretty significant deal. We'll back up on in a minute. But the reason that I want to highlight, bring it to your attention here is because the US Constitution explicitly spells out this utilitarian basis for patent law. What's the phrasing?
So Congress shall have the power to blah, 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 blah. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries.
Yeah, exclusive right. Oh, sorry, what's the first phrase? Yeah, so that phrase, that language of to promote the progress of science and useful arts is the important piece of this, right? Because it doesn't just say Congress should have the power to, to protect people's intellectual property rights. It says that the reason for doing so, or the way in which they do so, needs to promote the progress of the sciences and useful arts. Does that make sense? So fundamentally, it's baked into the US legal system that what we're trying to do with patents is maximization. That's like the TLDR in this case. To kind of highlight what that means, I think it's helpful to compare it to potential alternatives. One of the leading alternatives for kind of a theoretical grounding for making intellectual property laws coherent is a Lockean theory of intellectual property rights. Locke, I won't get too deep into this, but TLDR, there's a natural, the premise is that individuals have a natural right to the fruits of their labor, subject to certain constraints that we don't need to get into too much, but essentially the idea is like, you can sort of think of it through the prism of like, so long as your natural rights are not infringing on other folks' ability to maximize their own natural rights. So for example, exhausting a given resource is not something you have a natural right to do, but like, tilling the land or whatever it is. For Locke, most of this is grounded in like fundamentally a like religious argument, an understanding of like God having made available set resources, people being having a kind of divine, again, natural sort of inherent, like God-given right to like till the land, make use of animals, whatever. But even if you were to try to divorce it from the religious grounding of it, and philosophers differ on whether and to what extent one can reasonably coherently do that. The kind of core premise here is like, if you think about arguments that one might make for why they should get patents that are grounded in ideas like fairness, or and the idea that like, well, I put in all this labor, I should be able to enjoy the fruits of that labor, that sort of falls into this category. Part of what is so significant here is, I know I've sort of said this a couple of times now in a few different ways, but I think it cannot bear repeating enough. You will note the US legal system does not say this, right? The US legal system is not grounded in the idea that it is like, you need patents because it's unfair for you to not have them. One could imagine a version of the US IP regime that does. One could read an affirmative about that, one could read a about that, whatever. But that is not the current nature of the US patent regime. Everyone on the same page about that? Okay. There are a variety of other potential alternatives here. We aren't going to get into these now. I don't want to speak for it, but I would not be at all surprised if DKP's philosophy of IP lecture down the road does unpack some of this. But one quick example, there are a bucket of Hegelians who would say that you should be able to